Thank you for joining us for part 2 of our data privacy governance webinar. And so we are going to cover a little bit more of the privacy ombudsman as well as the privacy auditor functions, duties, and what we've seen thus far, and where we plan on going with future legislation. So we wanted to, before we get started, a few housekeeping items. One is, if you would like to comment, please put those things in the chat, and we will be looking at that throughout, but be answering those questions at the end, just to make sure that we've got we've gone through all the information that we'd like to convey. The second item is, if you are an attorney and would like CLE credits for this webinar, please put into the chat your name and bar number, or you can just email me with that information and I can submit that. It has not yet been approved, but it will be submitted after the webinar. So just wanted to make you aware of that we are going to try to have CLE credits available, and we'll pursue that after the webinar. So just wanted to kind of go over the evolution of data privacy. We will be discussing a few things here that we've discussed in the part 1, just to give a little bit of a recap, and then we'll move in more in detail into those things that are related to the ombudsman and privacy auditor. So just want to make sure that everyone is aware that we have been told at the League that this is a process of legislation that will be occurring year after year after year to help entities, cities, towns, counties, the state, be more privacy aware and still allow the government entity to function the way it needs to with the public, while still maintaining the public's privacy, and in conjunction with the Governmental Records and Management Act. So this is, in 2024 it was HB 491, in 2025 it was HB 444, and I anticipate we will continue to see different legislation related to privacy, AI, automatic license plate readers, the whole gamut of privacy and data governance. So be aware and look for those as the legislative session begins. I want to give a recognition and acknowledgement of the Office of Data Privacy has been excellent to work with in trying to help us navigate both the functionality of a city and all of the records that we take in as a city, and also maintaining privacy and making sure those two things still are able to happen with legislation that comes forward. So they have been very collaborative, and we will be having an annual conference, just so everyone's aware. An annual conference will be October 1st and 2nd, and so we'll present data privacy there as well, and we will have Chris Bramwell, who's the director of the Office of Data Privacy, being able to be there and offer support and answer questions. So if you're interested in doing so, you can watch that. A lot of the information that we have covered in part 1 and part 2 will be presented at the data privacy section of annual conference. And so you will receive a lot of the same information, but they will be there to answer any questions that you have. So the next, so let me just give and I kind of already did this, but first we're going to go over the data privacy part 1, just the key parts, data governance key people, and then talk specifically about the privacy auditor and the privacy ombudsman. So the data privacy part 1 recap, and I should mention that QR code that we put there, you can come back to, and that will direct you to our data privacy part 1 webinar that you can watch if you missed that and weren't able to attend. So feel free to take a picture of that, and it'll direct you there. These are the things that we talked about in the webinar part 1. We talked about designating the CAO and records officers, their responsibilities, collecting data and providing privacy notices, what the privacy program looks like and what you have to put into the report, what extensions or exemptions there are to those various dates, contractor requirements, training requirements, requests to amend records, the enforcement for noncompliance, and different municipal representatives that have been or will be selected through the state auditor. So those are the general recap of what we covered. Now, a few of these slides are the same slides from the last one, just for simplicity's sake, and I think that they adequately represent what's in the notice. So I wanted to go over this in GRAMA, and I should mention this, that a lot of what is in the Government Data Privacy Act, GDPA, was actually and is still in GRAMA. There are a few key differences. It does expand it, it does change it slightly in different situations, but a large part of GDPA is just a reiteration of what is already in GRAMA. So you'll notice on the left side there, the notice that needs to be provided is only related to private or controlled records. And then there's a list of things that you have to provide in the notice, such as identifying the record series that includes the information, state the reasons the person is asked to furnish the information, how you intend to use it, the consequences for refusing to provide the information, and disclosing the classes of persons and the governmental entities that currently share the information with the governmental entity. And as you can see, the color there from the left to the right, those are corollary to each other. The gray, however, is the new part. And you'll notice that in the gray it says basically anything that would be, well, I should say this. In the GRAMA, it's only related to private or controlled record. With GDPA, it expands it to both, or to all, private, controlled, public, and protected. The difference here is that for public records, all you need to have is a limited statement indicating that their personal data may be available to the public. You don't have to provide those other forms of information of notice to the individual. However, it does expand it to protected information. So if it's protected information, then those things would need to be given out as notice to the individual. How to provide notice, again, it's the same as GRAMA. You can either post it in a prominent place, you can post it as part of a document or on a form. This adds under the GDPA that you can add a QR code or put it onto a website. So so that's the difference here, is you can link it or provide a link, a QR code or a link to that notice. And as I said before in part one, this is what I would do, and I think it simplifies things, where you can just put a QR code. It's the same QR code on every form, and it goes to an extensive and lengthy privacy notice on your website. So that would be my suggestion, and you can take care of all of the nuances on your privacy notice on your website, and just include a QR code or a link to that on your forms. So here's a recap of the dates that are important. By December 31st, 2025, you have to initiate a privacy program. And at least for this particular round, all that means is you have to complete the privacy report as indicated in the code, but you don't have to submit it to any state agency, the Office of Data Privacy, or the privacy auditor. So after July 1st, 2026, all new or renewed contracts must have specific provisions that require the contractor to comply with the requirements of GDPR. Right now, that is not required. That is still something that we've been negotiating with the Office of Data Privacy, and that will be revisited when those negotiations happen. We recognize, and I think that we've tried to explain to the office, that being able to still obtain the services that each of the cities need and have relied upon, especially when a contractor tells the city, I'm not interested now in abiding by GDPR and having those requirements. That's a hard pill to swallow, and one that we're trying to address through negotiations leading up to the legislative session. By May 1st, 2026, and really, and I say that because of that being the date in 2025. So annually is ultimately annually, each of the employees have to that have access to data must take a training provided by the Office of Data Privacy, or a similar privacy training that has been provided by or created by your city or town, but it has to have the same information that is in the Office of Data Privacy training that they are providing. So the second part of that, though, is if you've got new hires, they have to be trained within 30 days after they've been hired. The last thing here is that by July 1st, 2027, all processing activities, processing of the data that you had in place prior to May 7, 2025, must be brought into compliance, and that's by July 1st, 2027. I say stay tuned here because there's still negotiations happening. Again, going back to that chart of evolution, there are many different pieces that are still being worked through. This date may change, but I would work toward that date so that everyone is in compliance by that date. But again, it's a negotiation that we're still working with the office to better prepare our cities and towns and be able to have them meet those deadlines. Now, on that, there is a process for exceptions and exemptions to those dates. The office has to approve it. It goes also reported to the board, Utah Privacy Board, and also is given to the auditor by way of notification too. So just so you know, those, if you apply for one of those, and that's in the code that you can do, just be aware that it will be going to those entities and possibly a heightened scrutiny of your city or town in the future. So I just wanted to make you aware of that, though. The last thing here is, that was a mishap on my side. This is, so that finishes off the recap. This is who's who in data privacy. Chris Bramwell, you may have seen him, but I wanted to show faces and names so that you know who they are and what they plan on doing. So as you can see there's training director, the deputy chief privacy officer who has worked tirelessly on trying to make the legislation better, and Elena Taylor, who is the data privacy ombudsperson, and Nora Kurzova as the privacy auditor, and Don Wood is the current representative on the Utah Privacy Commission. He is the county rep, and there will be eventually the auditor's office will pick someone that represents cities and towns. And so those are the individuals that are kind of key. And if you've got any questions, issues, that information is there, and you can get a hold of them or us, either way. So this is a privacy auditor. The state, so this is in, I should mention, in the lower left-hand corner, I have included a reference to the code section. So if you've got any questions, you can go there and it will tell you more and hopefully address your questions. So the state auditor shall, with the advice and consent of the Senate, appoint the privacy auditor. And this happened in February 2025 this year. The Senate unanimously confirmed Nora, and Mark Meyer is also working as the Utah's assistant privacy auditor. So you may see him as well. The privacy audits, and this goes back, this was a audit done in date issued January 22nd, 2024, and it said that only approximately 34% of the 1,600 plus reviewed entities were compliant with the requirement to create a privacy policy statement, and only 34% of that complied. And most entities, 66%, did not have a formal and properly published privacy policy statement. So that is something to work toward and see if you can work toward that by December 31st, 2025. I like to think that some cities, we're all in different categories of cities, and really with our staff as well. There's different reactions. If someone says the privacy auditor just showed up, some cities are going to say, bring it on. Other cities are going to say, I don't even know what that means. Does that even apply to me? Who knows? And then there are others that may have this reaction. This is the worst possible scenario, that they just showed up and we are doing absolutely nothing to protect privacy. So I think that there are at least some sort and fashion, and we all may, your city or town may fall into all of these categories depending on what area of privacy we're talking about. There's a lot here, and I wanted to put that up specifically just to show you that there is a lot of duties that the privacy auditor has here, and a lot of authority in going about and auditing privacy policies and the technical considerations that the cities and towns have put into place, the operations. There are a lot of duties here and a big scope, but there's some that I want to bring forward just to make you specifically aware on these. The privacy auditor, this is a requirement for the privacy auditor that they analyze details about the technology or the policy and the technology or policy's application, the information about the type of personal data being used, the information about how the personal data is obtained, stored, if you sell, if you share it, all of that information can be and is actually required to be collected in any audit, as well as what type of information you de-identify or anonymize, and what alternative technology you use or improve practices to protect privacy. They also then end up with a finding of whether the government entity followed the current privacy practices adequately to protect individual privacy. So these are the statutory guidelines behind what the privacy auditor will be doing, and they actually have in fact been going around and doing what they have called as the privacy audit health check. Now, it's unclear to me whether this is a actual audit or whether this is like a preliminary audit, because it includes all of the same information that I would believe would be included within an official audit. This is something that we will be discussing with the privacy auditor and how they intend to use that and what that's. But that aside, you will be approached by the privacy auditor, and there may be an opportunity that this gives you we are not doing a whole lot to protect individual privacy, and we need to do a better job. And I think that is the hope and the purpose behind these privacy audit health checks, is just to let cities and towns, before being held to the fire, that hey, there's some gaps here that we think that you should address. So there will, in these privacy audits, they have stated that there are a few things that they review: the team's knowledge of privacy best practices, existing internal policies and guidelines, the organization's ability to mitigate privacy risk with focusing on data and purpose inventory existence, use of notices and data mapping practices, and also the readiness to prevent or mitigate if there is a breach. There is a lot here, and so I wanted to give you an idea of what questions they have been asking different entities when they've been doing these health checks, just to give you an idea of what that looks like. So there are three different areas. The first one is administrative safeguards. They will be asking they'll be asking all of these questions in your health check and providing a score of how well you did. And so some of these questions you'll see is monitoring of privacy compliance implemented. Do you have a process for offboarding of employees? Are you actually doing regular privacy training so that it's not just the IT department taking care of privacy, it's not just the recorder's office taking care of privacy, but it's everyone has that on their mind as they go about each of their job duties. Am I protecting privacy? Am I giving out records that I shouldn't be giving out? And so this is some of the administrative safeguards. There's physical safeguards. How is the access to buildings monitored, or are they monitored? How is disaster recovery ensured? How is access to your device protected in remote locations? So like a VPN or and those types of things. How is your office space protected from unauthorized access? I do have to say that this is actually, I've seen this in action. In a city that I've worked for, there was a First Amendment auditor that came into the front desk, and the computer was out there. It was not a restricted area. No door was stopping them from coming in and recording. And the individual saw the individual come up and sit down and look at the screen, rightfully turned it off, and locked his computer so that whatever was on his screen was not available to be seen by the First Amendment auditor. So what are you doing to protect the visible space of each of your employees from unauthorized access to personal data? The last portion of this is that there's technical safeguards. Are your tech vendors vetted by the IT prior to engagement? Do you have firewalls, email filtering? Just the other day, on our system, we have a security check where we get to catch fish, and bogus emails come in, and our plants and test for us, and we identify that they're fish, and so that is. What training programs do you have in place that will help in that process of securing and making sure that personal data is taken care of? So you can come back to this. We're going to post this online just like we did Data Privacy Part 1. But these are some of the questions that have been asked by other cities. This comes from and so at the end, like I said, there's findings, and they will identify for that town or city where they feel like the maturity level, privacy maturity level of that entity is at. And so this is in the state privacy framework, and it will apply to all of the entities that will be audited or will be the whole point of what in speaking with the Office of Data Privacy, at least from their perspective, the push forward is progress. I mean, that's really what they are looking for. Is if you don't have any practices or any policies or nothing's been implemented, what is that one thing that you can do, that you can focus on, and that you can put into your privacy plan for the upcoming year for strategies that you're going to do to move your city forward in protecting privacy? In other words, if you're at level 0, get to level 1. If you're at level 1, get to level 2. And that has been the collaboration that we've seen from the Office of Data Privacy. Is this is where we want to go. Now, so with that being said, there are in this privacy health check that the privacy auditor has been doing, they have mentioned this town or city is at level 1 ad hoc. The practice may occur, but it's not documented. There's no policies, procedures, and it's more reactive than a standard procedure that they do. And that is based off of, again, answers to each of those questions. So that is how they get to this portion of the maturity level. Then there are privacy audit recommendations that they give. Now, in the one that I reviewed, the recommendations and the timelines, this is some of the timelines that they gave the individual city. And that is, immediately they should start consistently using privacy clauses for vendor contracts. And I'll talk a little bit about that in a minute. Prepare a template for breach notification to impacted individuals. And then, within a year, they had recommended preparing a report on data sharing for the state privacy officer and introducing device protection measures and physical security tools like privacy screens and locks as needed. So with it, I should say that this is coming from a privacy health check point of view. If you actually go through a privacy audit, and that privacy audit provides recommendations, then the city must hold a public hearing within 90 days after receiving the audit findings to discuss the recommendations and to make decisions on whether they want to implement those recommendations. And that's a public hearing that has to be done within 90 days. And then having to get back to the auditor's office on what's been done. Now, the audit, just so you're aware, if it is an official audit, it's reported on a quarterly basis to the Utah State Privacy Commission, and it's reported on an annual basis to the Judiciary Interim Committee. So it will be a part of discussion within the legislative session and really outside when the Utah State Privacy Commission meets, of different changes that they feel like need to be made based upon audits that they've done. So keep that in mind. There is a standard procedure in code that shows kind of the process for non-compliance of code, and so there seems to be, in my mind, multiple different ways that the auditor can approach the city. One is for simply non-compliance, and in that case, the Privacy Board instructs the auditor to investigate those violations. The city is given 30 days notice to cure. And if the city doesn't cure, then it's referred to the Attorney General, who may file an action to stop or require compliance. Now, there's really no teeth other than filing that action to force the city or the town to comply. Now, there are similar provisions in GRAMA that actually end up as criminal penalties for those violations and attorney's fees and costs. So be aware that there's penalties in the GRAMA section that are not within GDPA. That is one thing that we're going to address in future legislation, or at least in the negotiations. But that wanted to make you aware of that. Here are some of the concerns, and I just wanted to point this out so everyone is aware of where the league plans on moving forward, and some of the concerns that I have with the privacy auditor. The first is this privacy health check an actual audit or not? And if it's an actual audit, then there needs to be a public hearing, and we need to do things. Within this health check, it did say specifically that assessment did not review compliance with individual laws. So again, that is one of the things that I'm concerned about is, are we looking outside of what is required in the law for cities and towns to do? And so we'll be looking at the duties of the privacy auditor and how they correlate with the privacy ombudsman or ombudsperson, and how they correlate with the GRAMA ombudsperson, and how they correlate with the government records office director and the appeal process, and how they correlate with that last point. Legislation is to be a multi-year and an ongoing effort, and this is an evolution in privacy that we've been told multiple times. It's been in committee hearings, it's been by legislators and by the Office of Data Privacy, and so the question that will be posed in future legislation is, cities shouldn't be held to the fire if the code does not state that the city has to or doesn't have to do something. And so that's one of the concerns that we'll be bringing up in negotiations is, what is the point of these timelines if we're being asked to fix those things immediately and then being reported to the Privacy Commission for not doing those things immediately? So just be aware of that, but there are those duties currently in code that the privacy auditor can come and do those things, so just be aware of that, and ultimately try to make your city functional, but also maintain that individual privacy. The next portion of this is the privacy ombudsperson. This is in 63A 19501. The governor shall appoint a data privacy ombudsperson with the advice of the governing board. And so she has worked in the Office of Data Privacy and been a part of that. The duties that she has is to serve as a resource for both those of the public as well as the governmental entity. They also, or she also has the authority to mediate different data privacy disputes or complaints that have been filed, and can also raise issues and questions to the governing board, the Utah Privacy Governing Board, and any serious or repeated violations of data privacy to that governing board. And then after consulting with the Chief Privacy Officer, which is Chris Bramwell, she can post on the office's website a summary of the complaint and the resolution with different things that have come up. So I wanted to give you currently on the website, there are various opinions that have been posted already, and that I think that it would be helpful for you to go and read, just so you have an idea of what is the outcome of these different complaints. The first one being disposal of public health lab samples that had personal data on them. So that one dealt with disposal protocols. You'll see in 2505 and 2509, 2504, 2511, all of those actually, to some degree, have been dealt with by the GRAMA laws. And instead of having filed a complaint or anything like that with the Government Records Office Director, which replaced the State Records Committee, something was filed with the Data Privacy Ombudsperson. So the other more regular violation, or a complaint rather, that has been made is the minimization requirement under the code, stating that You should only obtain that information that you need to provide services. So if you need someone's name, make sure you know the reason you need someone's name, and do they really need to put their name. And so there are a few things, again, that we'll be discussing. Who decides whether that's necessary? Who decides whether a name is necessary, or and we'll be discussing that in future legislation. And so that, I just wanted to give you a spattering of those opinions. Now, just like I did with the auditor, we do have some concerns. Typically in a mediation, it's held to be confidential, and it's that there's due process. And in this case, the privacy ombudsperson can disclose those things to the governing board, and that there's no security in mediating a dispute rather than just letting it go to court or to an administrative body, judicial body, to decide. And so I heard from one city that said, I would never use the ombudsman, and primarily for that reason, that there's really a lack of due process, a lack of confidentiality, whereas in the instance of the government records office director, there is some due process involved. And so there have been some concerns there that will continue to be brought up. The scope of authority, again, should the ombudsperson be over issues that are solely related to GRAMA and are not related to the Data Privacy Act? That's just a question to ask. And then this ongoing effort, if it truly is the case that old processing activities should be updated as soon as reasonably practicable, but no later than July 1, 2027, then in these opinions, are cities being put to the, does this really mean anything when it comes to violations? And should they be held to that same standard if they are, say, at level 0 on their maturity level? So these are some of the questions that we plan on asking. And so lastly, it looks like we've got 15 minutes, but let me just know that we will be having a city representative selected by the state auditor. And here is the Office of Data Privacy website. They do have workshops, which I think are excellent and helpful, and a resource that if you've got questions, they have ongoing workshops that you can, if you get onto their website, it'll show you the day and time, and that you can sign on and review that training. They also have and are continuing to work on template data privacy forms and notices and different things that will help, especially those rural communities that don't have the same staff as say a bigger city. So and then this state privacy framework, if you have time that you just want to whittle away, and maybe this is just the attorney in me, but it is a good document to read, to educate yourself and to get really a bird's eye view of where the state wants to go, where it was, and the current state of how certain laws have interacted with one another. Before this came about, there were a lot of different code sections that dealt with privacy and how to deal with certain records. The hope is to eventually merge and have it all in one place. We're not there yet, but we're working toward that. So with that, it looks like we're a little bit early. I've got, let's see here, to have they considered the risks in disclosing privacy shortcomings related to cybersecurity? What does a public hearing on a privacy audit look like? Are we revealing items that could give bad guys a roadmap in how to get into our system? That is an excellent question, and unfortunately it's a question I don't have an answer to. I haven't seen that happen yet as far as a privacy audit. There are protections obviously in closed meetings that you would be able to talk about those, but it says it has to be in a public meeting. So that's the best I can give you, although it's not really an answer. But that is something that we can bring up when throughout the upcoming, before the legislative session, so upcoming session. I can understand it's frustrating to have the same burdens as being put on cities. We have expressed this, and that's why we're trying to work with the Office of Data Privacy to manage the immense workload that this requires of each city and town to do. We do have, if you are a town or a smaller city, we do have the local administrative advisor program at the league, and we've already seen a few areas where that has helped out to be able to help different smaller cities and towns to react to some of these new code sections. But that is really what we're trying to do, especially with more rural cities and towns that have one or two people is all they have, and now they're having to have this big workload put on them, and that's hopefully why we can get those things in place by 2027. And even then, I think that'll be a stretch for some to get to where we need to be. So one question here is Colleen Thompson, curious what prior processing encompasses and how far back. That's a great question. So prior processing, prior to May 7th, 2025, and I cover this a little bit in part 1 of the data privacy part 1 and the definition of what they use, but it's really anything that any process that you had going before May 7th, 2025 relating to how you manage data. So what I have been told is, well, and I can tell you this, that many cities have not been abiding by, and state entities have not abided by a lot of the collection requirements in GRAMA for years and years and years. And so as we spoke to the Office of Data Privacy, one of the things that he has brought up is we want this to be a fresh start. We want this to be, yeah, we messed up, we haven't done a good job in the past, we're going to change, this is how we're going to improve, we're going to get better and better and better. And again, going back to that evolution of cities and towns when it comes to privacy. So if you have questions related to, well, is this a prior processing? I would ask the question first, did we start this process after May 7th, 2025? Is this a collection, say you had a new, I don't know, say you started a new service at the city, or you used a new vendor that had different, after May 7th, 2025, that had different, took in additional information. Well, on that, because it was a new process that you hadn't done before and taking that information in, I would say that would be a new process. If it were done before and that was already a process, the vendor took in that information, the name, the address, and even things that they shouldn't be collecting, well, I would say that that's probably an old processing activity. Let's see. So just a follow-up question here. It looks like from Colleen. What about a building permit application from 2005? That most definitely fits the old processing activities. So if you've got forms, new forms that you've created after 2025 or May 7th, then those would need to be updated with a QR code or with a link or with or posted right in front of where you take in that information, or actually on the form. If it was done like a building permit in 2005, then I think that you're pretty safe to say that that is one of the things that you will need to correct, and you will need to put and change and put a QR code or abide by that by July 1, 2027. But that doesn't need to be done. It needs to be done, I think, in the as reasonably practical that you can do that, I think is what the code says. But if it's not able to be done, it can't be done later than July 1, 2027. So I know that all of the cities and towns have an incredible amount of forms that you use. To have to go back to each of the forms to put this QR code on or this privacy, and then come up with the privacy program and come up with the report and do the trainings and make sure that all of the employees that keep track of those trainings and when they took them, so that you're abiding by it in the future. I recognize, and I think that the Office of Data Privacy recognizes the immense effort that it's going to take to get everyone to the place that I think that they're trying to go. And so what I've been told and what I'll push back on every time is cities and towns can't be held liable or responsible if they don't meet those things right now. The whole point of what I've been told many times over is this is a process, and we know that. So I think that it's very it's important to let the state auditor, privacy auditor, know that, look, this is where we're at. We know that we're not in compliance with a lot here. We're working toward that, and we've got these dates in code that allow us to do so. So that's the approach that I would take. But I should say this, that those processes will take a long time to get up to speed. So I don't think that it should be the message shouldn't be, let's wait until June 2027 to update all of our processes. It should be, we've got to systematically change the way we do privacy and privacy notices and all of that. Now, with all of that being said, again, I hope that the message is clear in this webinar that we are still in negotiations, and it is an evolution, and there may be requirements today that we're able to soften and able to help manage the operational side of actually implementing these things into cities and towns. There may be resources that are provided, which the Office of Data Privacy is working on right now. So there are things that are still happening, and hopefully that helps. I saw one. It looks like the part one link was put into the comments there, and if you still need that QR code, maybe I can get there right there. There that is, and you can do that. So with that, it looks like we've got 2 minutes to spare, and you can actually enjoy your lunch that you started 58 minutes ago. So thanks, and feel free to reach out to me or any of those that are within the data privacy world at the Office of Data Privacy. So thanks, and we'll connect with you later.